Good morning, everybody, and Mr. Chairman, thank you for my introduction and for some investigation in respect of my family. Anyway, I'm just very pleased to have this opportunity to speak about trademarks in Russia. Just for Russians, it's very convenient to come to Alicante from Moscow because of a direct flight between two cities of about 5 hours, and so that's. I don't think that it is a reason why Forum Institute invites from time to time Russians to speak about our IP legislation. Anyway, I think it's a point for our officials to consider more seriously our membership in CTM or European Design Directive. But seriously, I'm going to speak about doing business in Russia, and I hope that you agree with me that Russia still remains and very promising, attractive market in respect of about 140 million of potential customers, and also one of the new growing markets together with 4 other countries of BRICS group. And I will speak about doing business in Russia from the side of trademark owners. And I'm going to consider just a few points this time. I'll start with some general provisions of registration and trademark in Russia, then switch to trademark use requirements in that country, and then speak about some enforcement issues of trademark rights and with the focus on internet, and finally we will speak briefly about trademarks in the customs union and the common Eurasian space. Some of you remember that yesterday Mr. Klaze of WIPO mentioned that Russia occupied last year the 3rd position among countries designated by the Medvedev system users. And I also have just some statistics with 2 slides just about our internal official figures. Just excuse me if that maybe that's not correct from technical point of view, but anyway, just you can see from this slide that we have a steady trend of new trademark filings in Russia for the last 10 years, and with just a decrease within a couple of years, starting from year 2009, it was connected with global economic and financial crisis. And last year we received from abroad about 61,000 new trademark cases. And also you can see that for this, within these 10 years, foreign applicants practically doubled their new filings, and who are among top country filers. Of course, the first position is occupied by United States with 41,000 new trademark cases, then Germany with 2,700, France with 2,400, Swiss with 16, Italy with 1,500, China with 1,400 new cases, and Japan with 1,000 new trademark cases. As I mentioned already, Russia is a member of the Madrid system, but also we are members of Paris Convention, TOT, STLT, and this agreement. And last year, about a year exactly, on 22nd of August last year, Russia joined the World Trade Organization and generally brought its IP legislation in conformity with the principles of the TRIPS agreement. From year 2008, we have for intellectual property law just the only one Bible. This is the Civil Code with its Part 4, which is completely devoted to intellectual property and substituted all previous special laws which still exist in many other countries, and maybe Russia is some kind of exception of national regulation of running IP law, and together with some other laws like the law on protection of competition and law on customs regulations, criminal code, codes on administrative offenses, and different governmental ordinances and state agencies' regulations. Altogether, they shape so-called legislative IP landscape in Russia. And why you should register a trademark in Russia? Just I have a few answers for this. Of course, just to get exclusive rights for a trademark, it should be a result of a state registration. Again, Russia is a country with a first to file principle, and there is no any use requirement before filing a new an application. Also, a registered trademark is an effective tool for enforcement of trademark rights, and for some cases, registration is needed. For example, for customs record or outdoor advertising labels in foreign script. For example, in Moscow, you cannot put a sign or just on the door of your shop, just in English or in French, without a registration of this sign or designation as a trademark in Russia. Also for licensing and franchising deals, etc. You can file with the Russian Patent Office, Patent and Trademark Office, a multi-class application. As I told you, we use also international classification of goods and services, and yesterday already it also was mentioned in some speeches that class heading doesn't automatically, even in Russia, cover all the goods or services included in the class. You can use also a grace period for claiming a priority of your first foreign application, which is 6 months. And for dealing with the Russian Patent Office, you need a registered trademark attorney or an agent. Also, you should be prepared for a two-level examination of your case. In your case, I mean a formal examination and a substantive examination. And if you have a smooth proceeding before the Russian PTO, you can get a registration within, from filing date within 12 or 14 months. During a prosecution, application can be divided, and also it became possible from year 2008 when we changed our law, trademark law, just to get a registration for a designation which might consist, for example, of 2 or 3 consonants. For example, like BW, BMW, BP, due to a distinctiveness acquired through the intensive use in the Russian market. Also, a big question of the language for your application, because most of you file, of course, your trademarks in Latin. But in some cases, and for some goods, we can recommend you to have a separate registration in Cyrillic. And later on, I will just give you a few examples of this. As to opposition procedure, we don't have any post-grant opposition, but opposition as itself exists. So if you do not agree with a decision of an examiner from a trademark department of the Russian Patent Office, you can file an opposition with the Chamber for Patent Disputes. And if in your position based on prior trademarks, so it can be filed only with limited 5-year period from the publication date. But if your position based on absolute grounds or some earlier rights like a firm's names, copyright, so it can be filed with the whole validity term of registration. As just already mentioned, we have a substantive examination, unlike just some other countries in the West, and so we should be prepared for such an examination, not only in respect of absolute grounds, but also relative grounds. And such an opposition can be filed only by an interested person. And I'll just give you an explanation of the who might be regarded as later as an interested person or party. Just for traditional trademarks, of course, it's possible to get registration for a word trademark, a figurative trademark, or 3D trademark, or a combination of these elements. As just non-traditional, we call them trademarks. Of course, we have now a few examples of getting registrations for color marks. For example, just I have a two on this slide, just for Record Benkiser and for Deere and Company. But for Deere and Company, this is an international registration with even particular indication where each of these two colors should be put on a tractor. Also, position marks are available for registration, just a few for Adidas and just one for Hugo Boss, and also just one registration for one of our famous oil companies, Lukoil. And I know that it has also gas stations in many European countries as well, and you can meet in such appearance these gas stations. And also registration of sound marks is available in just two of them. But if you replay, for example, these two sound marks, I just no skilled in the music, but I tried to distinguish them, but it was difficult. So maybe there is only difference, a big difference in notes, musical notes. And also holograms and tactile marks are possible for registration. And let's again speak a little bit about language for a trademark, especially in Cyrillic. Of course, for the time being, many Russian customers easily recognize trademarks in Latin. But on the other side, during its commercial use, for example, in documents, price tags, commercials, etc., the name of a product may, and in certain cases, must have a Russian equivalent. And also, from just another point should be kept in mind that registration of Latin and Cyrillic equivalent will strengthen your legal protection and prevent the potential registration of confusingly similar Latin or Cyrillic trademarks by other manufacturers. And in this respect, you should also I think that registration of a trademark in Latin may sometimes be cited against its Cyrillic equivalent, but not all Cyrillic equivalents to a trademark in Latin shall be considered as confusingly similar. And for what goods? For example, just for finance, fashion, and high-tech areas, Latin registration of trademark in Latin may be enough. For agriculture, foodstuff, or children items, just Cyrillic version is recommended. But for pharmaceuticals, both versions in Latin and in Cyrillic, and particularly its transliteration, not a translation. And also just speak a little bit about just this side of a possibility of registration Cyrillic trademark, Latin trademark in Russia. should be in a separate registration. For just an example, just the client filed the application for the themes in Latin for computer games, software for electronic games. But during the prosecution, just another trademark, themes in Cyrillic, you can see just on the slide, was cited. And this registration was valid for game soft. And as a result of examination, the themes was recognized confusingly similar to themes in Cyrillic, and the application of a client was refused. We filed an opposition against themes with the Russian Patent Office based on its misleading character of regarding the producer of the goods, and so we managed to cancel it. But in another example, just which is famous in our practice, I mean in Russia, at the end of the story, just not so was successful. And still now, if, for example, you come to Russia and go to some shops to find and buy coffee, we, for example, just with famous trademark of craft foods, Carte Noire, you can find also on the same shelf another bottle of coffee with the trademark Черная карта, which is a Russian translation. I just underline this fact of Carte Noire. And also the story was like this, that Carte Noire existed from the 80s of our century as an international mark in Russia. And about, later on, just a Russian company filed a trademark for Черная карта. And so we filed an opposition just against trademark application Черная карта based on similarity of earlier trademark Carte Noire. But Черная карта wasn't recognized confusingly similar to Carte Noire due to phonetic and visual dissimilarities. So just as a result of relative examination on relative grounds. So just maybe some advice, if you have trademark in Latin, just with a word or words which can be translated into Russia for some particular goods, you should think about filing a separate application for translation, and transliteration of this trademark in Latin, but as a translation in the Russian language, because they are phonetically dissimilar and visually as well. You can see from this slide. So, the Russian trademark law provides for mandatory use of a trademark, and as I already mentioned, no requirements of actual or intended use of a trademark exist for its registration. But you can use your trademark as it is registered, or according to some provisions of the Article 5C of the Paris Convention, you may use also a trademark slightly modified. What is a genuine use according to our law? That is a use of a trademark on goods and packages, and also on the internet, commercial documents, and in advertisements. And who is a user of your trademarks? And of course, an owner and the licensee and franchisee, and also another person under owner's control. What does it mean? We don't have in our law a particular definition of such a person which may use a trademark under owner's control. But from practice of the Russian Patent Office and the courts, they might be, for example, your dealers, distributors, or affiliated companies in Russia, for example, a daughter company. Of course, just up to today, just license and franchise agreements should be recorded at the Russian PTO. This is obligatory. And the franchisee must indicate also that the trademark is used under the agreement. But maybe you know that just many considerable changes are now just in the Russian parliament under consideration. And in April of this year, we already had the first hearing of the Russian parliament, which adopted in general these changes. And we expect to have the second and third readings by the end of this year. And one of the changes concerned that how to register, for example, a license and franchise agreements at the Russian Patent Office. Now you should present the whole text, and so just sometimes it's not convenient for both parties, and so it will be just facilitated, and it will be enough according to the change, and just to present to the Patent Office only a formal statement of signed by both parties that they, for example, signed the license agreement, and that's it. What are excusable reasons for non-use of a trademark? Just some of them, of course, you can find in the same Article 5C of the Paris Convention, but just for your information, I just put on this slide so that something beyond of an owner control, force nature, or force major, disasters, military actions, personal health of an owner, absence of raw materials, unexpected changes in the market. And this reason, for example, from our practice, are accepted by the Patent Office. And of course, just because trademark should be mandatory use in the Russian Federation, if you, for example, didn't use it within a period of 3 years from a registration date, so it becomes vulnerable for a cancellation. And again, such a cancellation action can be filed by the interested party, and the burden of proof lies with the owner of such a trademark. And also, you shouldn't forget about just another period of life of your trademark, not only immediately after registration, but even later. And so, if you should use it, but without any non-use periods exceeding 3 successive years, because if it happens again, just interested third party can file an opposition as a non-use cancellation. What documents are accepted for approving trademark use? Just I listed just a few of them, just shipping and customs documents, invoices, copies of any reports, also statements of or evidence from local representative offices, distributors, stores, price lists, copies of advertising materials in Russian language, and extracts from the Russian magazines, the newspapers, TV commercials, and so on. And but what is important that all these documents should contain indication of the trademark goods and the owner. Just mentioned about slight modification of a trademark. If, for example, during a life of a trademark in Russia, you decided a little bit change it, but you should be very careful just to do this because from one side it is acceptable to use a trademark with some modification, which do not alter its essence. But the question whether the change is significant or not is up to the IP court to decide. And so it is better, of course, to use a trademark exactly as it is registered, and just logical advice that you should register all forms of your trademarks in which you are going to use in Russia. And for just the interested party, Of course, first of all, that manufacturers or providers of identical or similar goods or services, owners of identical or similar firms' names in the same business fields, owners of similar identical or trademarks registered in other jurisdictions, and of course, an intention to produce goods or provide services in Russia, as well as the use of firm names or trademarks should be shown. And what are our recommendations? It is recommended that immediately after the date of registration of your trademark, you should start to collect an evidence of appropriate use of your trademark in the market. And all documents you could show that the trademark is being used in Russia must be compiled and effectively used in case of cancellation, and based on a non-use is filed by third parties. And a few conclusions on this point. Again, a trademark has to be used without significant changes for all registered goods and services. It's very important. And an owner has to collect evidence of his trademark use in Russia immediately after the date of its registration. If an owner is not a manufacturer of goods, he should grant a license, and such license agreement, as I told you already, must be registered at the Russian Patent Office in order to be accepted as an evidence to use of a trademark by a licensee, or the mark has to be used under owner's control. And this fact should be obligatory documented. You can, from our practice, successfully enforce your trademarks in Russia. According to our law, nobody can use without your consent a trademark or similar sign of goods or services which are identical or similar to those in respect of which the trademark is registered, if such use would like to cause a confusion. And goods and labels and packages of these goods on which a trademark or a confusingly similar sign are unlawfully used shall be regarded as counterfeits. What bodies are involved into enforcement of trademark rights in Russia or IP rights in general in Russia? Of course, just a few administrative bodies like anti-monopoly office, customs, police, and court. In Russia, we have exactly two branches of different courts which are involved into hearing of cases connected with IP rights infringement, including trademark rights infringement. That's common courts and commercial courts, which is a venue, proper venue for your case. You should keep in mind that, for example, if one of the parties involved into the disputes connected with the infringement of trademark is individual, so just you should go to a common court with all these instances listed on the screen. And if both parties are legal entities, so you should go to, and also not just another point, for example, all administrative cases and criminal cases are run by common courts in Russia. But if both parties are legal entities, you should go to a commercial court. And from the 1st of February of this year, we also have a new court on intellectual rights. We call it in Russia, but briefly IP court, which, as you can see from this slide, is built into the system of commercial courts. And for infringement cases, and this is, as you can see, a cassation instance in the system of commercial courts. But for appeals against all decisions of the Russian Patent Office or decision of anti-monopoly office and decisions and for oppositions connected with non-use cancellation action of a trademark, this is IP court is the first instance. And for these cases, there is no any appeal court. So immediately, case after the first instance in the appeal court will go to a collegium of judges will consider your case also in the same court, but as a cassation instance. And we hope that appearance of this new court will significantly enhance the competence in examining the conflicts in IP field in Russia, of course. And about liability prescribed by our law in case of infringement and what trademark owner can claim in general. Of course, an injunction, but it's possible also to claim just both interim and preliminary injunction, and also just removal and destruction of counterfeit goods, labels, and packages, and even equipment and materials used or to be used for infringement, and damages, including fair profits made by an infringer and his lost profits. And instead of damages, it's possible also to claim a compensation. And in this case, you are not obliged to prove the volume of damages, but the law provides for just a range of amounts of monetary compensation, just up to, it depends on, of course, currency exchange in Russia, just up to about 15,000 euros. Or it was just introduced recently that you also can claim it just in a double amount of total cost of all counterfeit products, or royalties, which would have been due if an infringer requested a license to use your trademark. And also, just it's possible in some cases we had even a liquidation of a legal entity of an infringer, and publication of a court decision. And just a little bit about trademark infringement on the internet, and who are liable for trademark infringement in internet. Just in Russia, of course, internet shops, their websites, and trading platforms. But these trading platforms shall be liable for an infringement if they fail to prove that the goods are offered for sale by another party, and they have no relation to them. And what you can do, you should, of course, it's advisable to start with a cease and desist letter. And if you don't have any reaction of another party, so you can initiate a civil action. And so just to collect evidence for your lawsuit, just what kind of evidence, you should certify the content of the website by notary public. Request the domain name register to give you information about the owner, and purchase just a product from this website, or some other evidences which you can find. And just a few examples, just when we have trademark infringement by, for example, internet shops. So there is a famous case just connected with the trademark L'Occitane. So just the owner filed a lawsuit against a few, just exactly 5 owners of the internet shops. And court established that according to the evidence presented by the plaintiff, all goods were labeled with the trademark L'Occitane and offered for sale from this website, the internet shop. And court wrote this as trademark infringement and recover the compensation in favor of a trademark owner. But the decision was confirmed because it wasn't the final story. I mean, it was a court of the first instance, but also a court of appeals and court of cassation, and even Supreme Court, commercial courts confirmed this decision. In Russia, we don't have a UDRP or the like procedure, and so such disputes under the competence of the courts. And what are general requirements for suing? That should be similarity of domain name and the trademark, similarity of goods or services, and of course trademark priority date should be earlier than the domain name registration date. Just a couple of examples, but they're the same, and when we had trademark infringement by a domain name. So just trademark Le Croix just was used as a domain name by just a Russian company, and court decision was just to prohibit the use of a trademark Le Croix in the domain name and recover the compensation for a trademark infringement, and the maximum which is allowable by the law, just about just 115,000 euros. It's the same, but only compensation was just as a minimum possible. That is another famous case. This case is remarkable just for the reason that just an owner of the domain name mom.ru didn't use it for any commercial activity. But anyway, the client, just a famous French producer of wines and champagne, Mom, and she just filed and owner of the trademark, international trademark Mom, sued this Russian individual, and the Presidium of the Supreme Court held that activities of Mr. Yusupov should be qualified as an unfair competition practice, and also as an infringement of exclusive rights of Mom company to the trademark. Another, just already in the morning session, we touched upon advertising awards in the internet, but we have just a little bit different practice and promising, just in respect of trademark owner rights. For example, this is a case we just Russian individual had a trademark Alpийская форточка. It means alpine vent in Cyrillic. For ventilating equipment, and once it has come upon to his attention that in response to the request for phrase Alpийская форточка in a search engine, the competitor's website was displayed in a contextual advertisement. And immediately trademark owners sued the competitor and submit to the court a notary public protocol of search engine results for the phrase Alpийская форточка. And he succeeded in this court proceeding, and the court prohibited the competitor to use the trademark Alpийская форточка as a keyword in search engine advertising. And also it's possible to sue owner of so-called meta tags on the internet. This is the case with trademark X-Pro, also owned by the Russian company NPO Engineers of Telecommunication. And while searching X-Pro in a Russian Rambler search engine, a web page from the site of company STR, with the website www.strtelecom.ru was displayed as one of the results. And the trademark owner sued the website administrator and submitted to the court a printout of HTML code of the page where the word X-Pro was used in meta title tag. So, just still have some time, Mr. Chairman? Yes? Just about a little bit about trademarks in the customs union and the common Eurasian community. Yesterday, just one of my friends in the clients, Linden Sprungli, mentioned that he met in the Russian market some fakes of chocolate produced by just Russians, but we should say that mainly counterfeit products come to Russia through customs and mostly from the east, particularly from China. But we have in Russia, in the Russian customs, so-called IP customs register, where you can put your registered trademarks or some copyright subjects. And today we already have more than 2,000 trademarks and copyright subjects are recorded in this register. We should say from our practice that this is quite a cheap, effective enforcement of your trademark rights. What it gives for an owner of trademark rights that customs is entitled to suspend a release of the alleged counterfeit goods for 10 working days. And you can get an information about such goods and importer, and also just have an opportunity to inspect the detained goods and even take samples. Upon your information, customs drafts an administrative report and files an administrative suit with a competent court. So, and the court can find an infringer, and counterfeit goods should be destroyed. But already about 3 years we are living as a country member of so-called the customs union, which was set up in the year 2010, and now we have 3 countries. All we are neighbors: Russia, Belarus, and Kazakhstan. And so, just the customs union has its own customs code, which provides for also IPR subject matters register, but which, to our regret, is not available yet. And in line with the agreement on common principles of IP rights protection and enforcement, the parties undertake to approve the principle of regional exhaustion of trademark rights. And so just during this year we have more problems with counterfeits which come to our country from the 2 other member states of the customs union. So you should keep in mind this point when you are considering your trademark strategies in respect of Russia. Also keep in mind these other 2 countries for up-to-date, also to get registrations in parallel to Russia. But we know that other 2 former republics of the Soviet Union are willing to join very soon. They are Armenia and Kyrgyzstan. So it will be, if Armenia joins, not if Kyrgyzstan joins, it will be a so-called nightmare for Russia and for trademark owners, because it's just a direct way from China to Russia. In addition to this union, we also have so-called Eurasian Economic Community, and as you maybe know, just that to get a patent protection in Russia, you use not only national way and international through PCT, but a regional possibility. We have so-called from 1996 so-called Eurasian Patent Convention. Like in Europe, you have a European Patent Convention. But for trademarks, we have only two alternative ways to get trademark rights through national and international. I mean, the Madrid system. Russia, again, repeats, a member of both agreement and protocol, but no any regional alternative. And so, just exactly on the 16th of May of this year, the Council of Eurasian Economic Commission approved a draft treaty of unified procedures of trademark registration in the member states of the Customs Union and the Eurasian Economic Community. In some general assessments, it might be considered as a model of just CTM, but with a few exceptions and principal exceptions, but one principal exception, that this treaty doesn't provide any central trademark office. So any national trademark office can be a receiving one for a so-called Eurasian trademark application. And so now three countries, Russia, Belarus, and Kazakhstan, are dealing with internal proceedings to prepare this draft for signing. The Eurasian Economic Community unites today 9 former republics of the Soviet Union, and they are I have just a list, excuse me, but it should be precise. Just here we have just a good player, Ukraine, Moldova, Tajikistan, Uzbekistan, Armenia. Probably that's it. Exactly, and we expect just entry in force of this treaty in next year. Okay, thank you very much. That's it.
Thank you very much, Mr. Medvedev, for your comprehensive summary and overview of obtaining and protecting trademarks in Russia. Any questions, Mr. Medvedev? Yes, please. Can you speak, please? Use the microphone.
No. No? Okay.
Hello? No, okay. When you said earlier in your presentation that for some trademarks you would recommend also to register them in Cyrillic or both, or what's the differentiation? Why for some goods and services Latin is sufficient and for others it isn't?
Of course, just again, it depends on just your strategy in the Russian Federation and how you are going to use your trademark, and for what kind of goods. For some goods, as I already mentioned, which lie in the field of high tech or fashion and finance, it would be enough to have just a Latin version of your trademark. But for example, for some goods for which we need to have a translation in Russian of your trademark. For example, for wines, for pharmaceuticals, it's obligatory, and that's why it's better if you register, and it will be easier for you to prove even a use of your trademark. But if you simply thinking about a separate application for your trademark in Cyrillic, but without any possibility to use it, it will be just a waste of money, and you cannot get anything just to strengthen your trademark registration in Russia. But it depends on the case to case. Yeah.
Yes, please, Deborah.
If the Cyrillic translation were registered, would use in the Latin format be considered a use in the Cyrillic translation format?
As to use, they will just exist because these are two separate registrations. So you should approve for use of both, just in Latin and in Cyrillic. If, for example, in case of non-use cancellation action by a third party, that's why you should, just as I just mentioned already, just answering the first question, that's not about theoretically of existence such an application in Cyrillic, but you should use it as well. Or in 3 years, and 3 years after publication of your registration, it will be vulnerable for just for attack by an interested person.
Yes, please.
My question is also related to these first two questions. Would it be correct to say that if there is an owner of an earlier right who has Latin transliteration of a subsequent Russian trademark for the same or similar goods and services, would always be successful in an opposition proceedings? This is the first question. And the second one is about cancellation for non-use, which can be filed, if I understood correctly, after 3 years from the date of the registration of a trademark. Is there necessary always to show a legal interest? Thank you.
Yeah. Just I'll start with the second question. Yes, but you also should keep in mind that we have it might be theoretically 2 periods for non-use cancellation action. Just immediately after registration. I mean, during first 3 years if you do not use, and also if you remember, I also mentioned that another 3-year period that during the life, for example, you should use your without long. Non-use period, which might exceed 3 years also, successive 3 years. And even later on, if you stop, for example, after 8 years of registration to use your trademark and will not use for 3 years, so it also will be possible to cancel attack your trademark in respect of non-use. As to existence of in just registration of a possible registration of your trademark in Latin as a transliteration, I think it would be possible for a third party, for another party, to register such a sign, such a designation due to just a result of examination on relative grounds, because phonetically, if you transliterate your, for example, English version, they sound just in the same way, and so it would be practically impossible. But a translation is with carte noire. It's frequently we have, for example, gamer in English and the grog in Russian. So they're phonetically different and visually dissimilar, and so it would be possible for the same, for example, computer games to have, and you should think about such separate registration for a grog, if you, for example, have a gamer in Latin as a possible trademark.
For example, a simple Russian word like "privyet," and an earlier mark would be just a Latin transliteration. So can you say that the general Russian public will always understand this Latin transliteration?
Yes,
or does it depend on the specific goods and services, like when it comes to mass consumption products bought on a daily basis or something really specific? Does it make a difference? But I'm just speaking about, not about translations, about simple transliteration into Latin.
Yeah, but as to, I think, as I already answered you, as to transliteration, it would be just impossible to get just a registration for just the same Latin trademark in Cyrillic. Yeah, because they're phonetically the same.
Mr. Gonda.
Thank you. Still staying with the same subject matter. I don't know how is it designated in the registry of the Russian Patent Office. Does it also contains the Latin transliteration of a verbal trademark or a verbal element of the trademark, or those informations are only available in Cyrillic letters? And especially what I would like to point out, how to carry out the search in that database. You can only do it in using Cyrillic letters, or you can also use it by simply typing in Latin letters.
If we have the transliteration of a trademark in Latin in Cyrillic, so you can find it only in Cyrillic as a transliteration. And the same, just as I just gave you an example with Черная карта, so it's the same will be in Latin, in Cyrillic language.
Isabel?
Yes, I have two questions. The first one is related to non-use. If I understand correctly, there is no provision in your IP code regarding trademark infringement because of transliteration or even translation. But if we file a trademark and in the same mark you have, let's say, the Latin word and the Cyrillic word, is it possible to consider that you use just one of them? Is it possible to consider that the mark is still valid because it has been used, the most important part of the mark has been used, which means that in such case you can file a trademark with the two, Latin and Cyrillic, without running the risk to lose your mark. Is it correct?
If I understood your question correctly, so just if you have two registrations,
No,
just,
one.
or just one.
In just one. So
In
you
just
put
one?
Yes, in the same mark you put
No, it's impossible to have in one just application two designations for registration. You should have only just one. For example, just in Latin, and another application for Cyrillic.
Why it's not possible?
Yeah, but because it's a law.
Because but you can have a real trademark which is partially in Latin and partially in Cyrillic. So it's
You mean just
it can be the mark.
yeah, but the mark is it in a phrase or just in a single word?
It's a single word.
But
and
if single word, it should be just one.
so it's not possible in Russia to have a mark which
Because there are two marks, yeah.
which is one word in Latin and one
Yeah.
word in Cyrillic.
Yeah.
It's not possible.
No,
It's not allowed. Okay.
should be two.
And my second question is about the jurisdiction. I understand that you have one more level than we have in our jurisdiction, because you have Cour de Cassation and the Supreme Court. So what does it mean in terms of decision? Which one is doing what? Because you have finally four levels.
Yeah.
So the Cour de Cassation is doing what, and the Supreme Court is doing what?
If you have just a lawsuit and you start with just for example in a commercial court. In a commercial court, you start with the first instance and you file just a lawsuit just on the location of your infringer. Yeah, because for example in Russia we have on the territory of the country about, if I'm not mistaken, 81 commercial court of the first instance. And then if, for example, one of the parties disagrees with a decision, so you have a possibility to file an appeal to appeal courts, and we have about 20 appeal courts in Russia. And then again, you can file an up if you just or another party disagree with, go to a cassation court. And then again, it's the fourth instance. It's just the end of just the story, which issues a final decision. So this case goes from down to up. Yeah.
The question was, what is the difference between the Cassation Court and the Supreme Court? What is their difference?
Yeah, but okay. The difference is that usually cassation courts do not hear the case. It hears the case only from formal point of view. That's, for example, if all procedural things were correctly implemented, but do not look at the essence of the matter. Supreme Court may rule this case just also to look at the essence of the case, but not only from formal point of view, from procedural point of view, but also just to look at the essence of the dispute.
So we find other differences between our various jurisdictions which are difficult to explain to the outsider. The notion that you have one level where you appeal procedural issues, another one, then the substantive, is kind of complicated to explain. Anyway, we thank you very much for a very interesting presentation, and the economic significance of obtaining protection in Russia, of course, will increase, as you point out. It's one of the largest markets in Eurasia overall, and obtaining protection and enforcing it is going to be important.